Good afternoon, respected Chairman of the Commercial Law and Economic Advisory Committee, Sanjay Agrawal sir. We both are at the Delhi head office. Respected faculty, CA Dr. Dilip Bhai, renowned faculty on the will, how to draft the will, probate. So he is the author of the book also. And respected members or those live watching the webinar on the will. Friends, our committee is always doing a programs how to scale up the practice. We know that we are not an expert of the other law, just like we are expert of income tax, GST, and audit. But the sum of law is not a part of our syllabus, and we can't read during our education. But now, as a business solution provided, we decided that our duty to bring expert faculty and give them knowledge of the law, which is essential for the practice. So this is our purpose of the programs. And in today's webinar on the drafting of will, which is very, very important, every person has a succession plan. And the will is the solutions. If you are your clients, you can advise them how to draft the will, you can charge it. And some of the lawyer I know whom they are charging rupees 1 lakh for the drafting of will. It's not so easy. So yeah, today there will be Dilip Bhai will appraise about the intricacy of the drafting of bill and how to probate the will. I will hand over chance to the respected Deepika Agrawal ji. She's already joined as a moderator of the programs. Deepika ji, are you here?
Yes, sir. I really regret
so
that I was late.
no issue. You introduce the chairman, sir, and then Dilip Bhai. First, the Sanjay sir will be addressed, and thereafter the.
Sir, the agenda has been done already.
Okay, please go ahead.
Okay, sir.
Yeah, thank you, viewers. Thank you, Dilip Bhai. Thank you, Deepika. CA Deepika. Let me tell you, friends, this committee, your own committee, Economic Law Committee, we are doing a lot of work which are non-conventional works. For example, we are doing in drafting of family wills. We are also doing RERA. We are doing in FEMA. We are doing in AML, anti-money laundering. A lot of courses we have in this committee. And all the courses there are overflowed whenever we have anything which is online. Physical also we are doing a lot of courses in this committee. You see, today, because of the change in the practice scenario, it has become very important to have the practice, to know the areas which are non-conventional, and labor laws, etc., which have been recently developed. We need to see to it that we excel them. And every time whenever there is a change in the law, it is the profession of chartered accountancy that they start taking the lead. So when this black money, this Benami law, it came, so our own professional, they have excelled. And today's faculty, as you all know, that he's the expert in this particular planning and will, etc. He has written a book also already, my vice chairman has said, and we have promised him that we will update it in the current scenario. Few of the questions which I haven't handled in my professional life also, as well as while I was member in the disciplinary, that when to witness a will, why to witness a will, and whether a professional can witness it or not. I was discussing before the starting of this webinar with Dilip Bhai that please also enlighten the member and also tell us why will is important and why the living will is also important. One of my colleague, he was suffering with the kidney failure. So he's a chartered accountant, but having no chartered accountant in his family. So one day he came and he said, I want to discuss you something personally. So I said, why you want to discuss something personally? You have the entire family. Oh, no, I want to discuss something. I want to have a will. So I said, okay, let us contact some attorney. You jot down as to what thing you want to give to which family member? No, he said, no, Sanjay, that is already a process I have registered. Then I said, then what you want? He said, I want to register a will because I'm a kidney patient and I know it. There will be a day when I will be hospitalized. And I don't want that I should go on ventilator at all. And I know the affection my son and my wife is having with me. They will not leave it unless until the doctors, everything they say. So I want to have a living will wherein I direct or I request my family member not to put me at any stage on ventilator. And let me tell you very frankly, Dilip bhai, that particular moment I could get the sentiment of my friend. So I immediately asked one of my colleague advocate that it is possible to do it like this. So he said, yes, a living will can be there. So that can be given to the hospital that if you have any such type of thing, for example, ventilator, for example, change in the kidneys, etc. So these are the few controversies which have developed now in these days. So we'll be requesting the faculty, whatever is the regular things, you may cover it, but cover some of the points which our professionals should know it, and they will see to it that in their life. Normally, what happens when any succession or any will is drafted, some of the family member may not be happy, some may be happy. So how to keep it secretly also, how to see it that wills are being registered and then known to the family member after the demise, because a lot of transfer of assets, etc. Those who are having good assets, they will have a problem if there is a will. I think that is not there. Now the settler, how the person who's made responsible in the will, how he has to settle the will. All these things I am confident that the faculty will handle. So over to Deepika for the rest of the proceedings.
Thank you so much, Sanjay sir. Sanjay sir, thank you so much for your wonderful speech. Your speech actually imparted the experience you have gained over the time in your professional life and personal life. Sanjay sir has been the Central Council member of Institute of Chartered Accountants of India since 2010. He has been serving the institute since a long time, and he had the opportunity of serving almost all the standing and non-standing committees and other committees in the Central Council since then. And he had been chairing the Commercial Laws and Economic Advisory Committee from 2026, Committee for Aggregation of CA Firms, MSME and Startup Committee as the Vice Chairperson. In 25-26, he had served the International Taxation Committee, Committee for Aggregation of CA Firms, and has been the Vice Chairperson of Research Committee of the Institute. So your success has been a tenure of success, we can say decades of success we have to mention. So he has also served as a Northern India Regional and Council member of ICI in 2004 and 2007. So his journey started in 2004 serving the institute, and it has been a long time since then. We have more than 22 years. So he'll be celebrating his silver jubilee very soon with the Institute of Chartered Accountants of India.
Thank you, Deepika. Thank you.
Thank you so much, sir. I would also like to introduce Vice Chairperson of the same committee, CA Purushottam Ji Khandelwar. He's a distinguished fellow member of ICI with over 28 years of post-qualification experience in audit, direct and indirect taxation, and intellectual property rights. He's a law graduate from Gujarat University, Ahmedabad. He brings extensive professional and leadership experience to the profession. He had several positions in WIRC, Ahmedabad branch of ICI, including Secretary of WIRC and Chairman of the Ahmedabad branch. Under his leadership, the Ahmedabad branch received recognition of the best branch of ICI, while WIRC was honored as the best region of ICI. Apart from his professional contributions, he has also been actively associated with social initiatives and served as the president of Rotary Club Ahmedabad Airport and Assistant Governor of Rotary District 3054, and currently he is serving as the Chairman of Commercial Laws and Economic Advisory Committee of ICI. Thank you so much, Purushottam sir, for heading this committee as a Vice Chairperson. Coming over to the session. So, this is a webinar where I welcome you all because it is a webinar which we all require at the depth because it is on will drafting intricacies and latest developments in living will and probate. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of the Law Committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws and economic advisory committee. Our eminent speaker will talk on will drafting intricacies and latest development in living will and probate in this webinar. And we hope the same will be very useful for all our members and all the people watching the ICI TV along with us. So, to coming over to a speaker, welcome, sir. We are delighted to have you over here. CA Dilip Satbhai ji comes over as a senior partner of Messrs. D.V. Satbhai and Company Chartered Accountants. It is a registered office located at Pune. He is a senior partner, was a chairman, vice chairman, secretary, and treasurer of the Pune branch. So again, he belongs to our ICI WIRC branch. It's a delight to know, sir, that all of you have served the institute at a wide span. His educational qualification, he is the mentor of the firm, holds a master degree in law, which he had passed out with flying colors by ranking first in the order of merit in the University of Pune. He has been conferred with a doctorate in law after completing a PhD degree in law in a subjected title, Freedom of Speech and Expression, and Media Trial, a Case for Judicial Activism. He was also on the merit or list in both the intermediate and final examination conducted by the ICI. He was the winner of the National Merit sorry, he is the winner of the special prize from Nehru Memorial Fund, New Delhi for professional excellence. He has been conferred with a special memento for recognition of professional services at the hands of Shri Sharad Pawar, former Chief Minister of Maharashtra and former Union Agricultural Minister, Government of India. The Mayor of Pune recently awarded him a special memento in recognition of his services in the education field. He has been considered a sound investment consultant in Maharashtra. He has masterminded amongst all law as he was a visiting part time faculty member and head of the Department of the Auditing and Taxation Department for well over 25 years with BMCC and ILS Law College in Pune, which are the pioneer colleges in their respective fields in Pune. Sir has also delivered many lectures and presented many papers in seminars and conferences on state and national levels and also delivered talks on All India Radio. He has rich experience in performing IS information system audit as he's a computer programmer, and SSI has awarded him a certificate of excellence and was declared successful in DISA as well. Sir has also completed his post qualification with various certificates provided by ICI and other institutions. So he's a very well qualified professional who has an experience of more than 2 to 3 decades now. He has authored 2 handbooks of ICI also. The handbook on chartered accountant to draft a will on the subject he would be speaking today, and handbook on nomination intricacies, again a subject related to the will. So he's a very well authored person, and we all will be delighted to hear you, sir. The moment this will topic comes up, we all should actually take it up very seriously because today's time requires a lots of thought by the elders because the family courts in India are filled up with these type of cases, and when we go to high court and supreme courts also, we see that most of the cases comes from the families. Around 60% of the cases which we are seeing are coming up from the members of the families against each other because of the father or grandfather not drafting the will properly. The problem exists. And if we come upon the real estate industry, as the in the recently I had an opportunity to meet Ashwini Vaishnav sir. He was in Jaipur. So when he discussed those things, it was actually going to the top of the pain of the real estate and the industries that when we buy a purchase or a real estate property, we come across the same problem that the will was not properly drafted, and many people after the purchase of the property comes upon as a owner of the property having some rights, and the cases goes in the court. So sir, not taking any more time of yours, I would request you to please take over the session and enlighten us with your deep thoughts and knowledge. Thank you. Over to you, sir.
Dilip sir, just to interrupt here, that we should take some of the question answer in the last. And Deepika, please ensure that like a cashier's cash in hand with the physical, when it tallies with the books, then only he'll be happy. So I think our purpose of organizing this webinar will be served if the members' queries are met. So this is my special request to Dilip bhai for deliberating. Over to Dilip bhai. Show is your.
Thank you so much, sir. I will make sure that the question and answers are sorted out reasonably. Thank you.
Thank you, sir. Two powerful torchbearers of the Institute, Sanjay Kumarji Agrawal, the chairman of the Commercial Law and Economic Advisory Committee. Another good friend of mine, Purushottamji Khandelwal, vice chairman of the said committee. Then Gupta madam, secretary of the committee, Mayank Vasudev sir, and moderator CA Deepika Jain. Good afternoon, all of you. Let us start with the topic in itself and let us brief it out what is required to be studied and what is required to be covered. Now, I have divided this entire representation into two parts. One is the conceptual part and the second is the applicational part. Conceptual part is very, very important. Unless you know the conception and many important features of the will in itself, you will not be in a position to deliver the goods in itself. So keeping that particular point in mind, some brief history and then definition and why will is required, what are the advantages of will that is being required. So all these aspects, including ingredients of the will, what are the important features which we need to look into? These are the matters which I'm going to highlight in the next 2 hours of time. So you all are aware life is inherently unpredictable, and one of the most significant uncertainties in life is the timing of our death. To address this uncertainty, various products offer guarantees that extend beyond our lifetime. It is always said, Jindagi ke saath bhi, Jindagi ke baad bhi, something of that sort. Consequently, it is prudent for every individual with property and assets to plan for their management, distribution after they are no more. So it is always said in our Maharashtra that a person sitting in the chair today may become a memory commemorated by a hanged photograph on the wall adorned with sandalwood flowers at any point of time, which means that a person sitting on the chair, when he will go on the walls, nobody will understand. And that is the reason why, to navigate this uncertainty effectively, it is essential to have a legal memorandum in place, ensuring that one's wishes regarding the disposition of the movable and immovable property to their loved ones are respected. This is precisely where a will becomes indispensable. So in short, what is a will? This is what the preliminary part, that what I specified about. Let us go into two important definitions of will. A will is a legally binding document. So once you write something in that, it becomes binding on all the persons to whom it may concern. That outlines how your assets will be distributed after your passing and can also appoint guardians for taking care of minor children. So it's a twofold effect that you have to keep it in mind, that it binds the others. Similarly, you can take the care of your minor children by appointing a guardian in itself. So this valuable legal document enables you to clearly express your wishes, ensuring that they are carried out with precision. The word used is precision, which means to the minutest correct level it will reach, and care about the exception which are provided in the law in itself. In the absence of a will, the laws of the country of residence will dictate how your estate is divided amongst your heirs, a situation known in legal terms as dying in state. So once you die, if you prepare a will, then in that case, it's a different story than that you die without making a will. So when you die without making a will, it is called as intestate succession, for which the personal laws of the Indian Succession Act will apply. But once you prepare a will, no law of the personal law will be applicable, and according to the wishes of the person who has jotted down in the will, that will prevail. That's the importance of will in itself, which surpasses the provisions which have been incorporated in the personal law, where it says that if you die intestate, then it will be applicable. Unfortunately, this can lead to unintended shocks for your loved ones, because nobody knows that what property one will get, and accordingly the matter changes the hands from one person to another. By preparing a will that reflects your desire, you can avoid such outcomes and ensure your wishes are respected. A simple two-line definition that has been provided in section 2 small h of the Indian Succession Act 1925. It states that a will is nothing mere but a legal declaration of intention of the testator. Testator, when the person who is making a will is called as testator, if the person is a male, and if the person is a female, it is called as testatrix. So the testator, with respect to his property, which intention he desires to be carried out into effect after his death. So first is the desire, and the second is its operation will take place only after his death. So two important parts are there. In the will, you have to declare that what you wish to transfer, that is one part, and that transfer is to take effect only after the death is being there. Halsbury's law also simplified the same definition, or even the German also has given the same. Now, the question which normally comes into the minds of common people, that why it is required, why we should prepare a will in itself. That's the million-dollar question that everybody asks when the question is posed to them that you need to prepare your will. For example, uncertainty in life is the first one. Death is a certainty, with approximate 1.5 lakh people passing away daily worldwide, of which around 20% are in India. This is the statistic I'm giving you. This translates to around 1 million deaths annually in India due to old age. Additionally, India records 25 lakh deaths due to hunger, 462 road accident, which is a record, which is called as a world record, 98 lakhs death from 2014 to 2021 due to insufficient medical care, excluding COVID-19 victims, 28 daily farmer suicides within Maharashtra, which is the highest number in the country. Given the unpredictability of death, it is crucial to have the will to ensure proper distribution of property to their desired beneficiaries in itself. So this is one reason, because life is certain, death is certain. Nobody knows when you are going to die, and that is the reason why, in order to ensure that your kids and your legal heirs are getting appropriate, adequate property in their equal proportion, the will be necessary. Second point, property without known legal heir. This is again a great deficiency that we have noticed in India. The report of the government, state government, central government states that due to inability of the owners to transfer the property through proper channels to their relatives, in absence of known legal heirs, the government is holding property worth several crores of rupees undistributed, which is still lying idle or unattended since very long, which otherwise would have been changed hands had there been a valid will. The latest available data shows that the total value of unclaimed financial asset, including bank deposits, shares, dividend, insurance policies, and mutual funds being held by the Indian government, exceeds 3.5 trillion rupees, 3.5 lakh crore rupees in 25. This figure is much larger than the previously reported amounts, reflecting growing accumulations due to people not claiming assets, especially in the absence of legal heirs. Let us see the breakdown. Approximately 90,000 crore is in the form of unclaimed shares and dividends. Bank deposits amount for about 75,000 crore transferred to Reserve Bank of India. Insurance policies worth around rupees 14,000 crore remain unclaimed. Unclaimed mutual funds rupees 3,000 crore. This does not include real estate assets and immobile property, which also would contribute significantly to the total above value just pointed out herein before. Why will should be prepared again? Government process and legal position. If a property owner dies with no legal heirs known or will after certain waiting periods, legal oversight, property is vested in the state under the doctrine of escheat or bona vacantia. The Bombay High Court and the Supreme Court have reaffirmed that the government can take custody of such orphaned property, particularly to prevent fraud and land grabbing. Current initiative. The Supreme Court of India has directed regulators such as RBI, SEBI, IRDAI to track dormant funds and their proposals for Unclaimed Property Authority, Centralized Unclaimed Property Authority, CUPA, to make claiming such assets simpler for more families. These figures show that the issue of undistributed and unattended assets is substantial and growing, with financial assets and potentially immobile property often remaining idle due to the lack of heirs and valid wills. Third important point, why will should be prepared. In India, as per the report, only 9 to 10% of the people only draft and write their wills, as against 46% to 60% in United States of America and other Western countries. There are certain challenges most individuals face when it comes to estate planning. Many wills lack one or more elements, such as not following procedural requirements and not updating the will in timely manner, etc. Many individuals are still associated with a wrong notion and idea of writing a will to death. Some think that will writing is what rich people normally do. However, most ignore that the fact that will enables the asset owners to transfer asset to the person they chose after the death of the asset owners. It clearly decides who should receive what. Without a will, assets are distributed according to succession laws, which may not reflect the wishes of the testator. For example, Mr. Rajendra Kulkarni died without a will. Under Hindu Succession Act 1956, his estate was divided equally among his wife and two sons. However, Rajendra had verbally expressed that his elder son should receive shop he was managing. Because of the fact that he has not written the will, his intention could not be recognized in law, and the shop was mandatorily divided amongst all legal heirs. So, despite his verbal expression in itself, since it was not jotted down in the will, the property could not go to the elder son. Second illustration, Mr. Arvind owned two flats. Without a will, both flats had to be shared equally among his three legal heirs under succession law. But he actually wanted to give one flat to his physically disabled son. Because he died intestate, the said didn't get any intended benefit. These misconceptions arising from financial illiteracy and are the major reason for not drafting or preparing the will in itself. Hence, to overcome these misconceptions about wills, mass awareness would be necessary. Point number 4, the unforeseen may happen. Failing to have a valid will leaves the deceased family vulnerable to the potential legal disputes regarding asset distribution among relatives and loved ones. This can lead to conflicts, increase the risk of distant relatives or creditors claiming the deceased assets. Intestate cases often require legal heir certificates, succession certificate, probate like court orders. This process can take months or causing stress, even years, and a financial burden. Example 1. When Mr. Ashok Yadav passed away intestate, his bank refused to release his fixed deposit without a succession certificate. His widow had to file proceedings under Section 372 of the Indian Succession Act, paying court fees and waiting nearly 8 months before gaining access to the husband's money in itself. Family members may be unaware of the full extent of deceased estate, making it difficult for them to manage or access them after their death, because it is normally the feature in Indian family that only the bread and butter earner normally knows what kind of properties and how much worth of property that he has been having. The knowledge is not shared among the family members. Additionally, in the case of social media presence, there is a risk of identity theft if no one has been designed to oversee the deceased online accounts are concerned. Example 2. Mr. Ajay, age 62, dies without a will. Mr. Ajay lived alone after his wife's death. He had one married daughter living in another city, a small house in his name, some bank deposits, a plot of ancestral land shared with extended family. He never prepared a will. Ajay's cousin, who lived in the same village, later on claimed that the ancestral plot belonged partially to his own family. Ajay had verbally promised him that the right to use the land was given. Since Ajay died intestate, he had the share in the property. This created a legal dispute, delaying the daughter's right to claim the property. 2 years earlier, Ajay had taken a private loan from moneylender for house repairs. There was no written agreement, but the moneylender suddenly filed a claim stating Ajay owed him rupees 5 lakhs with interest, put pressure on the daughter, threatening to attach the house. Without a will to show how Ajay intended to settle his liability and distribute asset, the daughter had to defend the claim in the court, spend money on legal fees, face stress and harassment. The daughter's inheritance was delayed because of this. There was no will. The daughter had to obtain legal heir certificate, succession certificate, probate like court orders for some assets. This entire process took more than 18 months, causing financial hardship to the daughter. Result: family members fought unnecessarily. A distant cousin tried to grab the land. A creditor demanded exaggerated dues. The daughter spent time, money, and effort in court. All this could have been avoided if Ajay had simply made a clear registered will. In short, will prevents family disputes, as most conflict arises when family members believe that they have a right to own the property or certain property. A will eliminates confusion and helps to avoid misunderstandings, claims by distant relatives, bitter court cases, long-term family breakups, which bring solidarity in the family and improved mutual trust and faith. Multiple legal heirs may create problems. When multiple legal heirs are involved and no will exists, it can lead to significant complications and disputes in itself. For example, Mrs. Shantabai Deshmukh, a 76-year-old widow, passed away in Pune. She had accumulated large collection of gold ornaments over her lifetime, including a highly valuable diamond necklace worth nearly rupees 18 lakhs. However, she did not leave behind a will. Shantabai is survived by 2 sons, Ramesh and Suresh. Their respective wives, Anita, Ramesh's wife, and Meera, Suresh's wives. After Shantabai's death, both daughter-in-law, Anita and Meera, claimed that the diamond necklace belonged to them. How the dispute started. Anita claimed that the necklace was gifted to her by Shantabai at the time of her marriage. Meera argued that Shantabai had verbally promised her the necklace to her, being the younger and more caregiving daughter-in-law. Since there was no will, there was no proof of Shantabai actual intention. The family broke into two groups. Ramesh supported his wife Anita, Suresh supported his wife Meera. Frequent argument led the brothers to stop talking to each other. What began as a family misunderstanding soon turned into a full-blown legal battle. Within a year, Meera filed a civil case in the district court seeking declaration of ownership over the necklace, injunction restraining Anita from selling or possessing it. Anita responded with her own claim of ownership. The court ordered finally the necklace to be kept in a bank locker under joint supervision until final judgment. After repeated hearings, after repeated hearing of 9 years, witnesses' statement, lack of documentary proof, the court held that the necklace formed part of the Shantabai's estate. Both claimant daughter-in-law had equal standing. Therefore, the necklace would be auctioned and the sale proceeds would be divided 50-50 in between Anita and Meera. By the time judgment came, the family had spent large sums on litigation. Ramesh and Suresh had completely stopped meeting each other. Their children never interacted. A once close-knit family became divided permanently. The message from this 9-year legal battle and the heartbreaking loss of family relationship could have been entirely avoided if Shantabai had prepared a simple, clear and valid will specifying who would inherit the diamond necklace and other ornaments. Why will should be prepared? Point number 6. Protects vulnerable family members. A will can ensure adequate protection for elderly spouse, minor children, disabled dependents, financially weak family members without a will. They may receive less or may face disputes. For example, Suresh Jagtap from Mumbai had a mentally challenged daughter. He died without a will. As per intestate law, property was divided equally among his wife, son, and daughter. The son latter refused to contribute towards daughter's medical needs. A will could have been created, a protective life interest or trust for her. Enables clear decisions regarding special assets. A will provides clarity regarding ancestral and inherited property, jewelry, sentimental items, business ownership, digital assets, bank logins, crypto, online accounts, investments, and insurance. Dr. Sehal Naik owned a copyright to several medical books. She died without a will, and her publisher stopped royalty payments until the legal heirship dispute was resolved. A will stating the beneficiary of intellectual property would have ensured uninterrupted income. Consequences of intestate succession if are to be avoided. When a person dies without a will, their property is transferred under the Hindu Succession Act. It is essential to draft a will. If an individual wishes to avoid the default distribution under the present law, then in that case, the will is required to be prepared. For instance, when a Hindu male dies intestate, his property is distributed according to the hierarchy. First it goes to class 1 heirs, then it goes to class 2 heirs, and followed by agnates and cognates. Finally, escheating the property to the states as outlined in the Hindu Succession Act. So 4 ways are there: class 1 heir, class 2 heir, then agnates and cognates, and finally to the government. Individuals must understand that without a will, the distribution of their property will occur according to these legal potentially against their wishes. The class 1 heir, I just made it out. Widow, son, daughter, mother, and all other 12 are there. Then class 2 heirs are there. But the difference in between class 1 and class 2 heir is that in class 1, if all the heirs are present, all will get equally. But that is not the case of class 2. If class 1 are not there and class 2 are only there, then according to the sequence, they will get the property. Entry number 1 legal heir will override the rights and interest of the subsequent number in itself. For example, if father is alive, then he will get the entire thing. The other from 2 to 9, they will not get anything. Then the agnates and cognates are there, per capita and per sterpis that I just mentioned about. Then there are certain exemptions to this Hindu Succession Act. Those exemptions are required to be covered up. The first exemption that what we need to understand is the Special Marriage Act 1954. Under Section 21 of the Special Marriage Act, succession to the property of persons married under that particular act is governed not under the Hindu Succession Act but under the Indian Succession Act 1925. So the exemption is not because the property is outside succession law, but it is because of the different succession statute that applies. The Indian Succession Act also shows that its own succession rules govern many non-Hindu intricacies subject to its exclusions and special provisions. Now, to whom this Special Marriage Act applies and to whom Hindu Succession Act applies? When the two persons are marrying each other, they are from the Hindu community in itself, Hindu Succession Act will apply. But if the two persons who are marrying with each other either are from Hindus, Muslim, Christian, Sikh, Buddhist, Jains, Parsis, Jews, inter-religious couples, Indian citizens marrying with each other, then an Indian national with foreign national, if the legal conditions are met, Indians living abroad in the situations covered by the Act. In these cases, Hindu Marriage Act doesn't apply, as a result of which Hindu Succession Act also does not apply. Here, Special Marriage Act 1924 apply, and hence Indian Succession Act will apply in these particular matters. Then stepchildren are not covered under this particular category, which is excluded from the Hindu Succession Act in itself. Then scheduled tribes are the third one, which are to be excluded in this particular matter. So I will give one small illustration. Dharmendra, deceased, is a Hindu male great-grandfather who died intestate without making a will. The estate is substantial and owned by separate property owner. Various heirs are alive. Some are dead, classified under the Act. Class 1 heir, A, alive, his son is there. So I'll just make out a table so you will understand the matter in itself. So if the son is alive, there are 5 legal heirs in class 1 category. All will get equally, and that is how one-fifth share that they are going to inherit so far as the things are concerned. Now, since class 2 heirs, agnates and cognates are still alive, but since class 1 category is there, others will not get anything. The last point, so far as the matter is being concerned, about the Hindu woman is being concerned, it will go to the husband and children, then husband's share, to the mother, father's share, and mother's share. In a very brief manner, that details we'll have to spend it out more time. So I'm just summarizing the details in itself. Now, this was about why will should be prepared. Now, the second important point that what we need to see, the importance of a will and then ingredients and advantages of will. Now, in case of importance of a valid will, the first point is avoids unnecessary family feuds and litigation. The significance of drafting a valid will cannot be overstated. A will not only streamline the estate planning process, but also family members avoid unnecessary disputes and litigation. Additionally, it protects the interest, the legal heirs from any relatives or claimants who may emerge after deceased passing, seeking a share of the estate in itself. Clear differentiation of the nominee from beneficiary. This is one of the most crucial points that everyone need to understand and evaluate as well. Because all the banks, mutual fund, they are asking us to provide their nominee in itself. They are under a general impression that nominee become the owner of the property at a later point of time. But that is not the case. That I just wanted to bring to your notice. One of the primary functions of the will is to differentiate between a nominee and a beneficiary. A nominee is an individual who holds the property temporarily under a trust until it is distributed according to the wishes of the will, while the beneficiary is the person who ultimately receives the property in itself. So clear-cut difference that beneficiary is the real owner, nominee is the temporary owner, just like a trustee. A well-crafted will allows testator to designate a nominee effectively from distribution of assets. One example, Miss Anandi, who has a bank account with SBI, nominates her son as the nominee, but later on writes a will naming her daughter as beneficiary for the same account. Upon Anandi's death, her son nominee only holds the account in trust until he passes that property to the daughter beneficiary, rightfully receives the property. So, in short, even if the nominee is the son, since in the will the now person's beneficiary is daughter, ultimately the property will go to the daughter. So, in short, we can make a statement when a will is prepared, the nominee's role is limited to facilitating this transfer, not ownership. So, that is what the peculiar feature which we need to learn. Planning guardians for minor children or dependents. A significant advantage of having a will is the ability to plan for plan for guardian and financial support for minor children or dependents. Without courts have sole authority to determine guardians and allocate the event of parents' untimely death. By establishing a will, parents can appoint guardians and designate financial resources to ensure their children's future's education. Now you can appoint executors also for social media management. In today's digital age, where social media can be having a very substantial source of income for individual, a will allows for the appointment of executors and manage the deceased online presence. This ensures that the revenue generated from the social media platform is properly handled and that the deceased digital legacy is maintained according to their wishes. Section 59, ultimately, who can make a will? This is the next point I'm talking about. Section 59 deals with who can make a will and provide that every person who is a person of sound mind, who is not a minor, can dispose of property by will. A married woman can dispose of by will any property which she could alienate by her own act during her lifetime. Persons who are deaf and dumb or blind can make a will if they are able to know what they do by it. A person who is ordinarily insane may make a will during interval during which he is sound mind, lucid interval. Conversely, if a person is ordinarily sane, he cannot make a will when he is not of a sound mind, as when he is under the influence of drugs or intoxicated. However, no person can make a will while he is in such a state of mind that he does not know what he is doing. The Calcutta High Court has observed that mere ability to sign his name or carry on ordinary conversation and answer familiar and easy questions does not necessarily constitute a sound and disposing mind. It is quite well settled law that a will made by a person who is a drunk or so much under influence of any intoxicant that he is deprived of his mental ability and a reason or his reasoning or understanding is void and having no effect. However, a will cannot be challenged only on the ground that its maker was a habitual drunkard unless it is proved that at the time of executing the will, he was under the influence of liquor. Mere old age does not disqualify a person from making a will, whether the person had sufficient mental ability to understand the nature of his testamentary act needs to be ascertained. Merely because of the old age has made memory rather feeble is no ground for nullifying his will. However, in cases where wills are made by old, sick, and dying person, it is not enough to show that such a person was able to answer usual or familiar question. It is also necessary to prove that he was fully able to comprehend the nature of his testamentary act and that he understood all aspects of the will when he has to execute it. It has been held that a will is not invalid only because of the testator made it just before committing suicide, provided that he was otherwise mentally fit when he executed the will. The testator was given an injection and a blood transfusion before the execution of will does not by itself invalidate the will if the testator was otherwise capable of making a valid will. As long as the provisions of the act are fulfilled, a person can give away his entire property by will if there is a residuary clause in a will. All property not given to specific legatees under the will would fall within the residuary clause and go to the residuary legatee. A Mohammedan who is of a sound mind, not a minor, may make a will, but it must be remembered that the principle of Mohammedan law, he cannot by will dispose of more than one-third of his estate unless the heirs consent to such bequest after the testator's death. Similarly, he cannot make a bequest to an heir unless the other heirs consent to it. In case decided by the Supreme Court, a will was made by a Hindu widow who was 70 years old. By this will, she bequeathed all her property in favor of brother's grandson in whom she reposed full confidence. The factum and the validity of this will were challenged by the sons of her husband's brother, who alleged that suspicious circumstances surrounded the will and it was therefore not a will. It was proved before the court in itself that the testatrix, that is the lady making the will, the old Hindu widow in the present case, was of sound disposing mind, although physically incapable of signing her name at the time of execution of will. Taking all the facts into consideration, the court held that the will to be valid as the suspicious circumstances were not proved. Another illustration can be Sayaji can preserve that going on his immediate neighborhood and can answer familiar question, but has no competent understanding to know the nature of his property or the person who are kindred to him or in whose favor he would be transferring the property that he should make his will. A cannot make a will is the answer. Iravati executes an instrument purporting to be her will, but she does not understand the nature of the instrument nor the effects of the provision. The instrument is not a will. Chandragupta, being very feeble and debilitated, is yet capable of exercising a judgment as to the proper mode of disposing of his asset. A makes a will. This is a valid will. What types of properties can be disposed of by will? The person who makes the will is called the testator male, testatrix female. A testator can dispose of by will by which they have absolute ownership. So in short, so long as you are the owner, only that much property is required to be specified. In Pune now, you might be knowing there is a Shaniwar Vada that cannot be disposed of by any Tom, Dick and Harry. The person who is the owner of Shaniwar Vada only can dispose it of. So you must be the owner. I cannot sell Taj Mahal in itself. The reason is that I am not the owner. So the person who is making a will must be the owner of the property. This is called self-acquired property. Recently, the Supreme Court clarified an important point on the law of inheritance of the property, that is whether a person can bequeath their self-acquired property to any person, and it includes property purchased by the testator through income, personal resources, property received by testator through gift deed or inherited through a will, ancestral property received by the testator as they share after partition. For example, a partition of joint Hindu family. So whatever is his share, he can will it out is the peculiar feature that just I wanted to bring to your notice. Therefore, the testator cannot give such entire ancestral property by will to its legal heir or to a stranger. According to the Indian National Bar Association, property inherited through a will is not considered as ancestral property. Ancestral property is passed down through generations within a family and is collectively owned by the family in itself. Once partitioned, it becomes a self-acquired property and can be willed to anyone. However, the Hindu Succession Amendment Act 2005 states that all legal heirs have an equal right to the ancestral property based on birth. This includes women who are considered co-partners and have the same rights as that of sons. If the property is legally divided among the family, each heir's share becomes self-acquired property and can be willed, is the important point. If someone dies without a will, their class 1 legal heirs will have the first right to the property. Now, what is the meaning of the word ancestral property? That ancestral property means a property that is devolved upon legal heirs by the 3 generations above them. That is father, father's father, and father's father's father. It passes on to the next 3 generation. The division of the property is per street piece that I already mentioned. If any person inherits property, whether movable or immovable, from his father or father's father or father's father's father, it is ancestral property as regards his male female issues are concerned. If he has no son, son, or son in existence at that time when he inherits the property, he holds the property as absolute owner. Therefore, it can deal with as it pleases as self-acquired property. A person inheriting the property by these 3 immediate paternal ancestor holds it and must hold on it in copartnery with his son, but regards other relation, he holds the property and is to hold it as his absolute personal property. So this was the one issue, and now the core issue, which is the main crux and the heart of the entire problem of the wills in itself, intricacies in itself. Now we have to evaluate that what are the ingredients of will. This has been considered to be the earlier part was only the part which you need to have a knowledge of it, conceptual knowledge that normally you need to have it. But this is the one that will show you how a will is required to be prepared, what are the important contents which we need to have while drafting the will in itself. And this becomes the core issue of the entire will that everybody needs to understand in a legal way. Now, point number 1, will is a legal declaration. Now, will is a legal document because why it is legal document? It has been made in conformity with the provisions of Section 63 of the Indian Succession Act to ensure that proper execution and attestation as laid down. So 2 important things are being there which are required to be highlighted over here. It's a legal document, that is what it's having a binding force. The major support comes from the Section 63 of the Indian Succession Act. It has been made by a person competent to make contract, because the important feature is there that the person must be competent to make the will in itself. Those who can make a will, we have already seen. It is the second important point. That is the reason why it is called as a legal declaration. The declaration should relate to the property of the testator which he wants to dispose of. Because there could be 2 properties that he might be owning. That one is where he doesn't want to dispose of, and the second is the one where he wants to ultimately keep it as it is. So in that case, the property which he wants to dispose of, the declaration must pertain to that. A major person is legally competent to make a will, and a will by minor is not a legal declaration, because ultimately will is a contract in itself in the technical sense, and that is the reason why minor cannot enter into a contract. It may also be noted that the mere use of the word will cannot make it a will if it does not amount to a testamentary declaration of disposing the property, which means that this is indicative of the fact that you must make a declaration that after your death the property must transfer or may be shifted from one person to another, including ownership. If the declaration contains no reference to the disposal of the property, but merely appoints a manager to manage the property or gives merely an authority to his widow to adopt it, then it is not a will in itself. So the basic point for a will is that you must be the owner of the property. There must be a clause to change hands from one person to another, and that changing of ownership must take place after the death of the testator in itself. In one case, a document was executed by a Hindu of advanced stage. In this document, he partitioned his property amongst his son, and the document was called as will. Amongst other, his so-called will contained the following clause. If at any point of time when I come back from pilgrimage and find mismanagement or the character of any one bad act, then I shall have the power to cancel this will. It was held that the effect of this clause was to make the document a family arrangement and not a will. Ramnath versus Ram Nagila. So this is the first important ingredient that what we need to understand, that he should be the owner. He must specify the property which he wants to change ownership from, and the transfer should take place only after the death of the concerned person. If the property is transferred immediately, it is not a will, is the major point which is specified in section 63 of that. Transfer intended to take place after death. This is the crucial fundamental point. The declaration as regard disposal of the property of the testator must be intended to take effect after his death. There has to be have a specific clause to that effect in the will. So will must contain, it may incorporate any property to whom it is required to be given, everything those could be there. But the fundamental point which needs to be added over there, that the entire matter which has been specified must be executed after the death of the concerned testator. Only this point will make that particular document as will in itself. If the declaration is not to that effect, if the declaration seeks to effectuate the intention of the writer immediately during his lifetime interviews, then it is not a will. A will written on simple piece of paper also derives legal value being a will. This is the most important feature that one needs to note about. Third point, revocability can be withdrawn. The essence of the every will is that it is revocable during the lifetime of the testator. A will always operates from the date of the testator death and not from the date of execution. So if the will is made on 1st of June and the testator dies at 15th of June, it will be executed from 15th of June and not from 1st of June. In other words, a will always speaks from the death of the testator. A will is revocable instrument as distinguished from a deed. Deed cannot be revoked in that particular technical sense, but this can be revoked. A will of a living person does not come into operation when it is executed, but only upon his death. So death should be the cause by virtue of which this will can come into effect in itself. A will is in its nature ambulatory during the maker's lifetime and is therefore always revocable so long as the testator is living. The only instance in which will cannot revoke is the case of mutual or joint wills which become irrevocable after the death of one of the makers. So as you might be aware that when joint will is being made and some joint commitments have been made, in that case, if one of the joint owners die, then that will cannot be revoked by the other party. This is what the meaning of that particular word is all about. Revocation means official cancellation of a decision. According to section 62 of the Act, a will is liable to be revoked or altered by the maker of it at any point of time. When he is competent to dispose of a property by will, the testator's right to revoke during his lifetime is also absolute. It can neither be waived nor can be restricted. Revocation of unprivileged will can be done by two ways. One, by revocation of operation of law. According to section 69 of the Indian Succession Act 1925, every will shall be revoked by marriage of the maker. The maker can be a man or can be a woman. This is revocation by operation of law. The principle upon which the will is revoked by marriage is that marriage creates such a change in the testator's condition with new obligations and duties. they raise an inference that the testator would not adhere to will made before the marriage. Every will, whether unprivileged or privileged, revoked by marriage of the maker. It means that when you are young, say 20 or 25 years of age, and made a will, and at the age of 31 now you have got yourself married, in that case, whatever your wishes are there in the will, those will stand revoked is the operation of law, because after age of 31 you will have a new family, new life in itself, maybe having children in future. So in that case, the entire procedure which has been laid down in earlier will now will not be effective, and under operation of law it will stand revoked automatically. Proper exceptions are property bequeathed by the executor who is empowered to do so, when two persons make a mutual wills that are specified as section 69 do not apply to Hindus. A will made by Hindu is not revoked by his marriage. Second is revocation by act of according to section 70 of the act, no unprivileged will or codicil nor any part thereof can be revoked by preparing another will or codicil, by some writing declaration declaring an intention to revoke the same and executed in the manner in which an unprivileged will is herein before required to be executed, or by the burning, tearing, otherwise destroying the same by the testator or by some person in his presence and by his direction with the intention of revoking the same. For example, Ram has made an unprivileged will. Afterwards, Ram makes another unprivileged will which purport to revoke the first. This is called revocation. Even if the second will mentions about revocation of the earlier will has not been made, the legal effect will be that the earlier will stands automatically revoked. Sham has made an unprivileged will. Afterwards, Sham, being entitled to make privileged will, makes privileged wills which purport to revoke his unprivileged will. This is a legal revocation. The fourth important point, stamp duty and registration fees. No stamp duty is payable on documents of wills and codicils. Hence, wills and codicils need not be written on non-judicial stamp paper. There is a misconception that all legal documents, in order to have a legal binding effect, should be written on non-judicial stamp paper of adequate value. However, if the wills are or codicils are written on plain or simple or piece of a paper in itself, still these documents are valid legal document. So the basic feature that is required to be remembered here is that it is not necessary to jot down the will on non-judicial stamp paper. It can be a general feature that on a simple paper or a piece of paper you can write it down. The registration fee for the will and the codicil are different in India as it is a state subject. In the state of Maharashtra, registration fee is rupees 100 only. Now, two witnesses. Fifth important point, the major cause for discussion as well as you may call it as a hurdle in the normal course of execution. Two witnesses are required. A will is a legal document that outlines the distribution of persons' property and assets after their death. The process of creating a will is governed by the Indian Succession Act 1925. One important aspect of creating a will is the role of witnesses in itself. These witnesses must be present at the time of signing and should not be beneficiaries of the will. So the major point that I just wanted to stress over here is, in India, two witnesses are required for a will to be considered as legally valid. More will be advisable. If you want to have more, no problem, but it cannot be less than two. And these witnesses, the most important part that I just wanted to bring to a notice and highlight it is that the persons who are witnesses should not be beneficiaries of the will in itself. The role of witnesses is crucial in ensuring the validity of a will. They are responsible for verifying the identity of the person creating the will, confirming that the person is of sound mind, understand the contents of the will in itself. They also ensure that will is signed voluntarily and without any pressure. Additionally, witnesses play a vital role in case of any legal disputes that may arise after the death of the person. If the validity of the will is challenged, witnesses can be called upon to testify and provide evidence about the signing of the will. It is important to note that witnesses must be competent to testify in court. This means that they must be of legal age, must not have been declared mentally unsound or disqualified from giving evidence in the courts of law. In India, it is recommended to have witnesses who are not related to the person creating the will, suggested, recommended. This is to avoid any conflict of interest that may arise due to relationship with the person. Witnesses should also be individuals who are likely to outlive the person creating the will so that they can be available to testify if necessary. In short, the will must be attested by at least 2 witnesses as under. Each witness must have testator sign or affix his mark, he must have seen some other person sign the will in the testator's presence under his direction. Each witness must have received from the testator a personal acknowledgement of his signature or the signature of such other person. Each witness must sign the will in the presence of the testator, although they need not sign in the presence of each other. Beneficiaries shall never be the witnesses to the will. This is a very important point. Ordinarily, wills are signed by the testator himself. However, a testator may, instead signing the will, put his mark, thumb impression, thereon, either because of his illiterate or because he is incapable of signing on account of weakness or fractured finger, for instance, or even through a sheer habit. Why will needs to be witnessed? Will is an essential document in which testator makes critical decisions about whom he wants to receive his property and care for his minor children after he is no more. Since will goes into effect after testator passes away, he is no longer around to confirm it truly belongs to him. That is where witnesses come in. They had watched testator signing the will and can confirm in front of the court that the document is authentic. Who can witness the will? Can anyone witness the will? In short, the answer is no. There are some basic requirements for who can witness the will. The witness should be of legal adults as per Indian Majority Act 1875 and of sound mind. They should also be disinterested, meaning they aren't related to testator by blood or marriage, and that they don't stand to inherit anything from his estate. The testator can choose the following people as his witness: a chartered accountant, friends, neighbors, co-workers, a lawyer, anyone else in whom testator has a trust. Who shouldn't witness? Anyone who is listed in testator's will and stands to inherit something under will shouldn't be the witness to avoid conflict of interest. This could include spouse or partner, children or grandchildren, anyone listed as a beneficiary in the will, anyone related to them, someone who is likely to pass away before testator, like a parent, a minor, or someone below the age of 18. If will is not witnessed, that means there is no one who has an authority to prove that the will is authentic. This could lead to a will being challenged in probate court and being thrown out completely. If the will is thrown out, then the estate will be distributed according to the Hindu Succession Act. Not having the will witnessed would likely cause delays and confusion for testator's loved ones and may result in his wishes not being followed as he may have intended. Sixth important clause, which is the ingredient, attestation. A mere signing on will by another person does not always amount to attestation. Attesting means signing a document for the purpose of testifying the signature of the person executing the document. It is not necessary that the witness should know the contents of the will. Many are aware of the fact that whether they should read out the will or otherwise, they may not know, still they can attest the will in itself. Executor of the will. An executor is someone who is named in the will to execute or manage the deceased person's estate. The executor is responsible for carrying out the deceased wishes and instructions, including paying off any debts, making funeral arrangements, and distributing assets to beneficiaries. The executor is also known as an administrator. Typically, an executor can be chartered accountant, lawyer, family member, the testator, the person who makes the will can appoint executor, or court can appoint one if there is no prior appointment made. So, in case the executor is not appointed by the will, then court can appoint an executor in itself. The executor may need to apply for special legal authority before they can deal with the assets in itself. Duties and responsibilities of the executor: meeting funeral expenses, obtaining death certificates, interpretation of will in the right manner and distribution of assets, drawing of inventory, expense management, applying for probate if necessary, payment of money that is due from testator, settlement of assets, maintaining records, representing testator in a legal action. Advantages of being appointed as an executor: beneficiary shall be ensured of proper handling of property. By appointing third person as an executor, the family can be relieved of administrative responsibilities of executing the will. If the executor is appointed in time, it shall save time, money, and shall prove to be advantageous to the beneficiaries. Many cases have been pending in the courts due to family disputes, which can be avoided by appointing an executor who will be the neutral and fair in his dealings. Executor not disqualified from being a witness. An executor is, however, not disqualified from being a witness. In other words, although legatee cannot claim under a will if he or his spouse is a witness to the will, there is no such bar on executor, and thus the same person may validly be the executor as well as the attesting witness. But in such case, he cannot take legacy or other benefit under the will. So this is the major point about executor. Then the medical practitioner certificate is required. It is advisable to have a doctor as one of the attesting witnesses, especially in cases where the testator is old or infirm or hospitalized, or where the will is likely to be challenged after death of the testator. This is done so that the doctor can testify, if need be, that the testator was of sound mind and understood what he was doing. However, as observed by the Supreme Court, there is no rule of law or evidence which requires a doctor to be present when the will is executed. Signature of the testator. Either the testator must sign or affix mark to the will, or the will must be signed by some other person in the testator's presence under his directions. Intention behind signature is also important. Such signature or mark must be placed that it appears that it was intended to give effect to the writing as a will in itself. Testamentary guardians, section 60. Then to general rule enunciated in section 59 that the testator must not be minor, there is one exception to be found in section 60. It lays down that father and he alone, whatever his age may be, can by will appoint a guardian for his minor children. In such cases, the father's age is immaterial. This is very important point again, because if under the Hindu Minority and Guardianship Act, if the person gets married prior to the age of majority in itself and produces children, in that case, this particular clause will be applicable. Today, however, child marriages are not illegal but not permitted. So this is restrictive clause. Once it is performed, it becomes legal. But the law, Child Marriage Restraint Act 1978, prohibits such type of marriage, but does not penalize if the marriage is performed. Registration of will. Under Indian Registration Act 1908, there are few documents that have to be registered compulsorily, has been specified in section 17 of the Act. So in short, section 17 says which documents are required to be registered under Indian Registration Act. However, the registration of will is not incorporated in section 17. Under section 18 of the Registration Act, it is provided that registration of will is not mandatory or compulsory. However, it is advisable to register the same. It has more evidentiary value. In the case of Ishwar Narayan Singh versus Kamata Devi others, it was held that by Supreme Court that non-registration of will cannot be held as a reason for the invalidity of the will. Thus, it can be concluded from the above precedent that it is not mandatory for anyone to register a will, or it cannot be said to be invalid just on the ground that it has not been registered. In the case of Madhya Engineering Vidyapit, etc., the will was put forth as one of the documents under section 18 of the Indian Registration Act, for which registration is only optional. In the case of Rayali, the court held that no adverse presumption could be drawn if the will is not registered. It was also suggested that the non-registration of the will was a very material circumstance against its truth, and the explanation offered for non-registration was palpably false. So these are the important features of the matter. 11th point, language and writing of will. No technical words need to be used in will, and a will can be in any language. However, the words used should be clear and unambiguous so that the mind of the testator is reflected in such words. It is not really important whether a will is typed or is a Word document or handwritten, or if the latter, whether it is written in ink or pencil. However, the English courts have held that if a will is written in ink, the testator has made pencil alteration therein, it will be presumed that the alterations were deliberately made. Technically, making a will should be simple, affordable, hassle-free, and safe against litigation to distribute a person's assets and property among legal heirs after her or his lifetime. As per Indian law, a will, irrespective of whether it is handwritten or typewritten on a plain paper, is a clear language witnessed by at least two persons, is a legally valid will. Registering a will by visiting court of law, getting a notary to attest it, is simply optional, not mandatory. Creating a will should be straightforward activity and is not a rocket science. Yet many will makers make silly mistakes while writing a will. With a bit of counsel, they can easily avoid these follies. The biggest folly is not caring about drafting your own will at all. Free from patent and latent ambiguities. Ambiguities, there are two kinds of ambiguities. One is patent and the second is latent. Patent ambiguity is one which is clear on the face of it or face of the document. For example, Shankar says in his will, I give 2,000 rupees, but name is not specified. The space is blank. No legality is mentioned. The ambiguity is visible on the very face of it, and it is instance of patent ambiguity, which is dealt with by section 81 of the Act. If there is a patent activity, one visible on the face of the will, extrinsic evidence is not admissible to show what the intention of the testator was. If the testator has kept his will incomplete, evidence can never be given in order to complete it or to add to it or to explain the incomplete portion. Thus, the legacy does not take effect in such a case as per the will. Example, a man has an aunt Sita and a cousin Gita and no aunt in the name of Gita. By his will, he bequeaths 1000 rupees to my aunt Sita and 1000 to my cousin Gita, and afterward bequeaths 2000 to my before mentioned aunt Gita. There is no person to whom the description given in the will can apply, and evidence is not admissible to show who was meant by my before mentioned aunt Gita. The bequest is therefore void for uncertainty under section 89. Shankar bequeaths to Rajesh so and so rupees or my estate of so and so. Evidence is not admissible to show what sum or what estate the testator intended to insert. Latent ambiguity, on the other hand, is one in which words are used which, although unambiguous, are capable of being construed one way or the other way. Section 80 deals with the latent ambiguity. The general rule is that oral evidence of the testator's intention is not admissible unless there is a latent ambiguity. Example gratia, to explain a nickname if the ambiguity is latent, that is, the words used are unambiguous, extrinsic, evidence can be accepted by the court to clear the picture. Example, a man having two cousins of the name Sita bequeaths the sum of my cousin Sita. It appears that there are two persons each answering the description in the will. That description therefore admits of two applications, that is, meaning only one of them which can have been intended by the testator. Evidence is admissible to show which of the two applications was intended. Ram by his will leaves to Love and Kush his estate called Ayodhya Budruk land. It turns out that he had two estates called Ayodhya Budruk land. Evidence is admissible to show which estate was intended. Now, inconsistent clauses. Sometimes will contains inconsistent clauses. The following three rules are required to be followed in such case. Every will has to be read as a whole, and meaning is to be gathered from the whole instrument and not by disjoint regarding reading of the various clauses. The true intention of the testator has to be gathered not from isolated expressions in the will, but by reading the will as a whole. Example, where a testator having an estate bequeaths the whole of the estate to Yash, and in another part of his will bequeaths one part of its one part of which is called Golibar Maidan to Vijay. The latter bequest is to be read as an exception out of the first, as if he had said that I give Golibar Maidan to Vijay and the rest of estate to Yash. Where a clause is susceptible for two meaning, one having effect and the other none, the former is to be preferred, section 84. But no part of the will is to be rejected if a reasonable construction can be put upon it. An attempt is to be made to reconcile the apparent inconsistencies and contradictions in a will. However, if that is not feasible, the general intention of the testator should be given effect to, even if it involves the rejection or transposition of a particular superfluous or even misplaced word. Where two clauses of the gifts in a will are not capable of being reconciled, as they cannot possibly stand together, it is the last clause that ultimately will prevail according to section 88 of the Act. The testator, by the first clause of his will, leaves his estate of Pune to Riddhi, and by the last clause of his will leaves to Siddhi and not to Riddhi. The estate will go to Siddhi. If a man at the commencement of his will gives his house to Raj and all the close of it, direct that his house shall be sold and the proceeds invested for the benefits of such, the latter disposition will prevail. Then the form of the will. There is no prescribed form of the will. It needs to be only properly signed as tested as required by the Indian Succession Act. The intention of the writer to convey the benefits by the instrument which would be conveyed by it, if considered as a will, provided the writer had the necessary intention or animus testandi. A will, though formally executed as such, will not be valid if there is no animus testandi, if it was written in jest. If the necessary animus testandi is present, Even agreements, letters, bills of exchange, powers of attorney may operate and take effect as wills, provided that under such animus testandi, the dispositions are not to take effect until after the person's death. 15. Residuary legatee. A residuary legatee is one to whom the testator gives the surplus or residue of his property after the legacies and bequests are made. A residuary legatee is constituted by any words of testator showing an intention that the person designated by him shall take the surplus or residue of his property. So in Kangana makes her will, consisting of several testamentary papers, in one of which are contained in the following words. I think there will be something left after all funeral expenses, etc. I give to Akshay, now at school, towards equipping him to any profession he may hereafter be appointed to. Akshay is constituted to be the residuary legatee. Nirav makes his will with following passage at the end of it. I believe there will be found sufficient funds in my banker's hand to defray and discharge my debts, which I hereby desire Harshada to do it and keep the residue for her own use and pleasure. Harshada is constituted to be residuary legatee. Amarnath bequeaths all his property to Balvinder, except certain stocks and funds, which he bequeaths to Kalicharan. Balvinder is the residuary legatee. Codicil. Codicil means an instrument made in relation to a will and explaining, altering, and adding to its disposition and shall be deemed to be part of a will. So, codicil is nothing mere but the amendments which are required to be made in the will. Section 2 small b of the Indian Succession Act defines that codicil. A codicil is a legal document that modifies an earlier will either in part or in whole. It can add, remove, change provisions in the will, but it does not replace the will itself. Codicils are typically used when someone wants to make small changes to their will rather than creating a new one. A codicil must be executed with the same formalities as that of the will itself, and it must be signed witness in the same way. The will maker must sign and the witnesses must be present. The codicil is then attached to the copy of the original will. A codicil can be used to change the executor, update beneficiaries, update guardianship wishes, protect beneficiaries from tax consequences, revise end of life wishes. Can a will be challenged after death in India? Yes. A will is a formal statement of testator's intention regarding both his movable and immovable property. A will can only be carried out after the testator has passed away. If the testator's assets are distributed before to his passing, the document is not a will. The validity of a will after death may also be contested in court, but only within a limited period of time work. Therefore, continued validity of a will is crucial. There is no time limit on when a will goes into effect. For a period of up to 12 years after the testator's death, a will may be challenged. So 12 is the time limit that you need to consider. According to the Supreme Court's ruling in Jamnadas Naveen Thakral's case, the civil judge may waive the 12-year deadline if there are valid reasons why some parties may not have known about the will for a lengthy period of time. However, this could compromise the natural justice. How long a will is effective? A will is still effective, valid, enforceable even after the testator's death. However, there is only a 12-year window in which to contest a will, and if someone wants to do it after that time, they must provide justification. The will is deemed to be executed if its provisions have been carried out. Indian law does not have any particular provisions governing the longevity and duration of the will in itself. The term permanent will refers to a will that has been in effect for more than 12 years or more. In conclusion, there is temporal limit on the duration of a will's validity because it is valid for beneficiary's whole lifetime and is always enforceable. Now, the benefits of will from chartered accountant's point of view are the one that what now we are going to discuss about. The first is tax planning through wills is the major issue. One, HUF creation, Hindu undivided family creation. A will can enable tax planning by facilitating the creation of Hindu undivided family if the testamentary document specifically bequests assets to an HUF, which can then become initial corpus for the new HUF entity. The legal process. The testator must clearly state in the will that the property is bequeathed to the HUF of a particular person, that is, HUF of his son, with all co-partner as per Hindu law. After the testator's matters in itself into existence, if it consists of more than one member, that is the intended recipient and family members, the beneficiaries, usually the son and his family, can draft an HUF deed, apply for a PAN, HUF name, and open bank account for HUF, establishing its status for the tax purpose. So, in short, once you prepare a will and bequest some 10,000 rupees for the creation of that HUF in itself, that is possible, that become the corpus of the HUF in itself, and new baby in the eyes of law under income tax law can be created. In CIT versus Ganesham Das Mukim, 1979 Supreme Court decision, the court held that HUF can be brought into existence via a valid will that bequeaths asset directly to the HUF, even if HUF did not exist at that time the will was executed. So even if no HUF is there, still you can create the will, is the Supreme Court decision. A father executed property in itself, and he shall pass on to his son, Mr. X, comprising of his ex with wife, children, thus creating a HUF within inherited property as its initial corpus. Tax planning benefits. The new HUF is a separate tax entity allowing for income splitting, utilization of basic exemption, and separate deductions under Section 80C, thus effectively reducing the overall family tax liability. This process must be carefully worded, executed in accordance with both Hindu law and the income tax regulations to ensure the property becomes HUF property upon the testator's death and secure desired tax planning benefits. Second important benefit for chartered accountants: creation of private trust for minors. Now, there are two types of trust normally one will come across of. One is the public charitable trust, and the second is the private trust in itself. Now, the main difference, or the only difference that I would like to specify about these particular trusts would be that when the beneficiaries in the trust are identified, when the beneficiaries in the trust are identified, it becomes a private trust. And when the beneficiaries are unidentified, then in that case, it becomes a public trust. For example, a grandfather has created a trust for his minor grandson named Ashok. And the person in whom the property is vested is trustee, his friend. So in that case, Mr. Ashok is the beneficiary, the grandson of the grandfather. So as a result of which beneficiary has been identified, it becomes a private trust. But the second category can be, I have created a trust for the benefit of all those patients who are coming for cancer treatment. I don't know the beneficiaries in itself. They could be n in number in itself, and as a result of which the trust will be called as a public trust. So the litmus test is nothing mere but the beneficiaries are required to be identified in case of private trust, and in case of public trust, the beneficiaries are unidentified. So the Indian Trust Act 1882 ultimately governs the private trust, whereas in Maharashtra Public Trust Act governs the public charitable trust. So private trust can be created for minors through will is the benefit that I'm just bringing it to your notice. A private trust for minors can be established through a will to provide for minor children and to defer their benefits until they reach majority, or as per the settler's instruction, which helps prevent the income from such assets being clubbed in the hands of parent under section 64(1)(a) of the Income Tax Act. So this is what the major benefit that they are going to get. Professional example. The testator parent drafts a will specifying the creation of a private trust for the benefit of minor children, naming a trusted individual or institution as the trustee. The will directs that the minor's inheritance be held in trust until child reaches the specified age of 18 or 21. The trustee is authorized to use trust fund for maintenance, education, healthcare needs. Such structures are widely used by professionals and high net worth individuals to ensure minors' financial security and compliance with succession law. If Mr. A bequeaths 50 lakhs in his will to a trust for his daughter, who is currently a minor, with instructions for periodic payment for her education and maintenance, the income generated is taxed in the trust hands and not clubbed with Mr. A's income due to trust arrangements. Legal example. In practice, the Indian Trust Act 1882 governs the creation and operation of such trusts. The trust deed, whether created during life or through a will, testamentary trust, should clearly state the beneficiaries, trustees, trust corpus, and the conditions for distribution. Courts have upheld the validity of testamentary trust where intent and terms are unambiguous and the property passes to the trustee for minor's benefit until a future event, such as attaining majority. This structure ensures both legal and tax compliances. Proper structuring and documentation are crucial to ensure the trust is recognized and the tax benefit deferred clubbing under section 64(1)(a) is achieved. In a leading Supreme Court case addressing private trust for minors, clubbing provision CIT versus M.R. Doshi, the court held that if the trust deed or will provide that income accumulated from assets bequeathed to a minor shall only be handed to the beneficiaries after attaining majority, then the income earned in the minor's years will not be clubbed in the hands of either parent under section 64(1)(a) because the minor receives no benefit in those years. This is the peculiar advantage that everyone gets. In Ganesh Chabarbat Vallubhai Patel's case, the Gujarat High Court distinguished Doshi's case, noting that while income can be accumulated and withheld tax liability on the trust income exists every year in the hands of the trustee under section 161(1) and not the minor or the parent in itself. So this is very important point that you can create a trust in the name of minor. The clubbing of income will not be there, which otherwise would be there had that trust not been there. Assets transfer. Assets can be transferred by will without consideration, and the clubbing provisions under section 64(1) do not apply. Is another benefit when assets are passed on due to inheritance rather than giving gift during transferor's lifetime. Legal example. The Income Tax Act stipulates that the clubbing provisions under section 64(1) take effect primarily when the assets are transferred by way of a gift or for inadequate consideration to a spouse, daughter-in-law, or HUF during the transferor's lifetime. However, if an asset is transferred via will, testamentary transfer upon death, this does not trigger the clubbing. That's the major provision. This is because the relationship of the transferor and transferee ceases at the time of death, and income arising from inherited asset after the testator's demise is accessible only in the hands of the legatee or heir. Example from tax commentary. Mr. A makes a will and bequeaths his property to his wife. Upon Mr. A's death, the property passes to the wife and all rental income after that is taxed in her hands, not clubbed with the late husband as per section 64(1), which is the best benefit that is available. Benefit number 4. tax benefits. Annual charges for daughters. A will can specify an annual charge on property for the benefit of daughters, ensuring they receive periodic payments or maintenance from the estate after testator's death. This technique is used in professional and legal estate planning to secure financial rights for female heirs. Example: a testator owns a rental property and executes a will that bequeaths the house to his son, but creates a charge on the property such that the son must pay rupees 50,000 annually to each of his daughter from the rental income as long as they live or until a specified condition, that is marriage, attainment of financial independence, is met. Such a charge is enforceable in law, and the legatee owns the asset subject to the obligation to pay annual charges to the daughters. This provides a recurring benefit similar to the annuity and maintenance rights guaranteed by the testamentary document. Example from legal practice. In property partition cases, courts regularly enforce testamentary charges, giving daughters an annual payment from the proceeds or income from ancestral property even when ownership devolves on sons or others. The courts have clarified that these annual charges form legal encumbrance on the asset and cannot be ignored by the inheriting party. Then the fifth advantage, charitable bequest. A charitable bequest via will allows the testator to dedicate certain properties for charitable purposes by forming a charitable trust, enabling trustees to claim income tax benefit exemption under Section 11 of the Indian Income Tax Act 61. A testator executes a will stating, I bequeath my house property to be held in trust by my appointed trustee for establishment of XYZ Educational Foundation, whose sole purpose will be to provide free schooling and for unprivileged children in the locality. The trustees register the trust, apply for Section 12AA, 12A, and run charitable activities using rental income from the property provided the trust complies with all tax requirements, spends 85% of the charitable income on charitable activities, obtains necessary registration. The income is exempt under Section 11. The trust can accumulate up to 15% of income for future charitable use, and donations received can also qualify for exemption as corpus donation. In John Vallamattam versus Union of India, the Supreme Court clarified that Section 118 of the Indian Succession Act cannot restrict charitable bequests by will and recognize the freedom to designate property for public charitable purposes. Courts have consistently upheld charitable bequests when the will explicitly states the intention and the trustees properly administer the funds per the stated objective. For example, when A bequeaths land via will exclusively for a cancer care hospital trust, income from the land, if applied for the hospital charitable trust, is tax exempt under Section 11. Charitable trust set up as testamentary instruction must be registered either to the statutory compliance to maintain their exemption under Section 11. Proper legal drafting and trust management are essential for claiming and retaining the exemptions. Sixth, executor taxation. According to another sixth benefit, according to Section 168 of the Income Tax Act 1961, the income of the deceased estate is taxable in the hands of the executor until the distribution of assets is complete. If there are multiple executors, the estate's income will be taxed as if it were an association of persons. Each executor is assessed separately from their own income. Mr. Sharma passes away, leaving a substantial rental property and investment to be inherited under his will. His daughter, Miss Sharma, is named as sole executor. For each financial year after Sharma's death and until the assets are distributed, Miss Sharma must file a separate income tax return for the estate. Tax rates and provisions apply as if executor is an individual taxpayer. Any payment to beneficiaries during administration are deducted from the estates from the estate of the estate taxable income, and only undistributed estate income remains in the executor's taxable pool. The estate's income, rental income, dividend, etc., is reported as the executor of Sharma's estate, completely separate from Sharma's own salary and investment. Legal example. In the case of estate of Hemraj, the court clarified that if there is only one executor, the estate's income is taxed as that of an individual. If there are two or more executors, the estate's income is taxed as if the executors were the association of persons, regardless of their personal income. Each executor is assessed for the estate's income using a PAN assigned to the estate. Their own salary, interest, business incomes are filed separately and are not included in the estate's assessment. Point 7. Ensures wishes are honored. A will can confirm that testator's belongings are allocated amongst according to his wishes. If you pass away without leaving a will, the state will decide how your estate is dispersed. The precise proportion is specified by the property's worth as per the state. The only method to guarantee that your wishes are carried out is to have a will. Choice of legal guardian. Your will allows you to designate legal guardian for your estate. If you do not specify someone, the law will appoint guardian on your behalf. This person will be responsible for settling your debts, closing your accounts, deactivating bank cards, and distributing your estate. Selection of trustworthy executor. By creating a will, you can select reliable and impartial executor to oversee the distribution of your assets. Choosing someone you trust gives you peace of mind that your wishes will be carried out as intended. Minimization of inheritance tax. A carefully drafted will can help reduce the amount of inheritance tax that your heirs may owe after your passing, ensuring more of your estate is preserved for your beneficiaries. Guidance for custody of minor children. In the unfortunate event that both parents pass away simultaneously, a will serves as a formal document outlining the custody arrangements for minor children, providing clear guidance on their care. Reduces having a will alleviates stress for your family by ensuring your wishes regarding your remains and funeral arrangements are known, respected, allowing them to focus on grieving and honoring your money. Faster property settlement. Generally, settling an estate with the written will is quicker and most cost effective than doing so without one. The importance of estate planning. There is a widespread apathy towards estate planning, with many individuals believing that drafting a will is unnecessary. However, if you want your asset to be passed on to your chosen beneficiary, creating a will is essential. One challenge is in estate planning is drafting a will that is unlikely to be contested. Recording the will writing process on video can help ensure that your intentions are clear and reduce the chances of disputes. So this is what the major issues, advantages that what we are going to have. Now it is only 5 minutes to 5 in itself. Deepika, would you like to say something? Because there are still more topics to be covered. Should we have questions on this topic and then we should proceed, or should we have one more lecture? Deepika, are you listening? You are unmute.
Thank you so much for the session, sir. It was really enlightening, and everybody got a very good insight about the will. So, as we have received around 22 questions, so I'm taking them one by one. Is registration of will compulsory? Is asked by Rajiv Balwant Pethe.
No, registration is not at all mandatory because the registration process takes into effect only when Indian Registration Act 1908 talks about. There is section 17 which I just mentioned in the will in itself, which I specified that there are certain items which have been specified, those are required to be registered. This is one item that will registration is not specified therein. So registration of a will is not at all mandatory, though it is advisable to get it registered.
Thank you, sir. Now we have Amit Jain. He has asked a question. As per the will, there were four beneficiaries. The executor of the will distributed 80% of the corpus of the deceased to all the four beneficiaries within 3 months of the death of the person who has written the will. However, later on, there was dispute amongst the beneficiaries, and one of them is not coming in the meetings to close the 20% of the assets. What should be done to close the will?
No, it is the duty of the concerned executor to get the entire property disposed of according to the directions which have been given by the testator. If that is not being performing, then the remedy can be sought through the courts of law. That is the only remedy that is available, because we cannot force, or they cannot force the executor to get the things executed. If they are not performing, court of law will be the district court will be the proper authority to go and ensure that execution is being done.
So there's a another question by the same person. Will execution fees? It is a percentage of corpus value. I would like to know how much fees is being charged by the executor of the will in India, who is a chartered accountant.
It depends on the relationship of the testator and executor. That amount is normally a person executor is a trustworthy person. It is not a paid job in the technical sense. It is the faith that ultimately matters over there in itself. So there is no prescribed fee which is prescribed under the laws as such. So it depends on the person. Normally, I have been executor at least in 200 wills, but I'm not charging even a single penny out of it in itself. So it depends on the faith and the social work, the charitable activity that is being performed, and helping others, giving back to the society is the main reason of becoming an executor in itself. So it is not advisable to charge any fee. But if someone is charging, then the matter needs to be settled down, and execution should be made. But executor cannot say that I am doing this only for the purpose of making money in itself, because that is not being agreed upon at the time when he was being appointed as the executor.
So we have to finalize it before finalizing the executor as per you. It depends upon case to case and your personal
Yes,
relationship with your client. I
yes,
hope the
yes, you are
question
right.
is answered well. So we have a question from CA Shailesh Uldwareshe, but I think you've already covered it. Still, I'm repeating in case you need to justify something more. Nowadays, there is a concept of forming liquid trust instead of will. What is that, and is it really better than will? I think you've already covered the entire topic. Then we have from Nitin Chandra Rimai, what document will be accepted as declaration of the testator if the property is situated outside India?
Now, that is the area that I have not covered, because you must see the slide in itself, which is there, that will of the non-resident in India. In that particular case, when the person is a non-resident in itself, then there are two
Sorry to
possibilities.
interrupt, sir. He's saying if the property is outside India, the
That
person
is
is
what I'm
not.
saying. Property, there could be two persons who might be having property outside India. One person can be non-resident in India,
Yes.
basically an Indian citizen, and the second can be an Indian resident residing but having property outside India. So two possibilities are there. In that particular case, if the property is located outside India, then the local laws of that particular country will be prevalent, and whatever ruling that will be given, that will have to be probated inside India through a court of law. Then and then only the execution or the distribution of property that can be made. So that is what the answer in substance that I can make it out.
Then we have Sham Ondar. He has asked whether will can be registered any place other than the place where person resides.
Normally, it is Indian Registration Act, so there is no problem about that. But there are certain states like Bihar and Jharkhand, they are not accepting the places where the person happens to be from other state in itself. But a place like Maharashtra, you can get any will registered and codicil registered in Maharashtra. Registration is a central act, so there is no bar in that. Anywhere, any place, you can get it registered.
Sham Sundarji has another question again. Is the oral will you as is an oral will valid? Oral will.
I'm not getting.
सर इफ somebody records a vocal like किसी ने बोल दिया तो वो will को valid मानेंगे या नहीं मानेंगे? If I record a
No,
message in my mobile and say that this is my will.
no, there must be a piece of paper, the word that has been used, it must be jotted down. Now the printed word is also been accepted as it is, but there has to be a definite way by virtue of which it can be authenticated that the message was being sent by the concerned person only. Otherwise, one can use mobile of other person and can write anything. So that authentication has to be there. Once authentication is there, then there is no problem because even writing a will on a simple plain paper or a piece of paper also is acceptable as a legal document.
So
Even
it's
written
important.
document that what we normally see in computer document, once it is printed, becomes a will in itself in the technical sense.
Then Preeti
It need not be
Rajchandani.
jotted down, it must be typewritten. It can be even in hand also by
So
written
video will also
handwritten.
not work? Video will. Video
Video
will.
will do that. That is one way that nowadays that has developed. Video will is another issue, but that must be supported by documentary evidence.
Okay. So there's one more question by
Because
Preeti
video will
Rajchandani.
cannot be registered. Video will cannot be registered in the technical
Okay.
sense.
So, sir, previously we had a thing that will is okay even if it is not registered. So, if somebody records a video will, it is considered as a registered. It
It
is
is
considered as a
considered
will,
as
but
it is
not
an
registered will.
evidentiary value is there for
But
that.
there might be certain controversies later on if it is not
Yes,
documented.
yes. They can write a normal piece of paper and then even if it is not signed or even it has not been done or somebody other person has signed, still that will be considered as a will on the basis of video will.
Okay. So we have another question from Preeti Ralchandani. If the witness to a will has expired, will the will be valid?
No, witness dying is a normal state of affair because he normally witness is the person who normally identifies because there is a difference in between witness and attestation. Attestation is nothing mere but the person agrees to become and testify the matter. That is one issue. And witness is that he has only seen that the person who has made the will ultimately has signed in his presence. So that witness, if it died, then the evidentiary value of the consent will decreases. That is what the only disadvantage is there. But the person which is attesting itself dies, then in that case, more evidentiary value is lost in that particular case because there is nobody to testify in that particular matter.
So, sir, it's always preferable to get your will registered to avoid any legal controversies later on. Will you say?
Yes, that is right. That is because it is always advisable to have these two persons of a comparatively younger age so that they will survive the testator in itself and they should be in a position to testify as and when it is required because 12 years is the period within which the will can be challenged. So if the person dies at the age of 70, then normally considering minus 12 years and another 12 years, the younger person should be there of that particular age. So normally a generation gap witness is being preferred.
So, question from Chandrakant Kinni. He's asking a question that is it necessary that witnesses should be aware the contents of the will or that they should read the contents of the document before witnessing?
Contents of the
Basically, should the witness read all the content and understand what is said in the will before signing?
no, no, that is not mandatory. He need not see the entire contents of the will. His job is only to ensure that the person who is making the will signs that particular will. The contents of the will need not be seen, need not be read, and need not be even evaluated, or somebody should tell them that these are the content. No, it is not the requirement of the law.
Okay, so then there's a question from again CA Shailesh Uldwarshe. Nowadays, for registration, will has to be uploaded on the portal. Is it advisable to upload a signed will by all? Of course, post submission, the testator and the witnesses will do the needful as desired.
No, that has to be the because when it is to be uploaded, the witnesses and the testator has to approach the registration authorities, and there they have to put their signatures. Because in Maharashtra, this is the situation. Because once you go for registration of a will, the person signs, his photograph is being taken, the witnesses also sign, their photographs also has been taken, and then only it gets registered. Otherwise, it is not getting registered. But in other state, the similar situation is not there. First, they draft the will, signatures are being made, and only it is documented by way of registration in itself. So that's a two different categories and ways by virtue of which the will is being registered.
He has another question. Is it necessary to take consent of the executor?
No, that is not required because the consent of the before he signing the will, before mentioning his name, his consent is required. Otherwise, he simply can say that I will not act as an executor, and in that case, the matter will have to go to courts, and another executor will be appointed by the court. Because
So
unless
can-
the consent is there, normally his name will not be incorporated. Because
Thank you,
the
sir.
executor is such a person who is trustworthy of the testator, and unless because he is having more faith than what his wife or his husband could be there, and that is the reason why the executor. Otherwise, normally executor is either the spouse or the elder son or daughter, as the case may be. But when you choose a person other than a person from a family, in that particular case, the person has to be trustworthy, and his consent is taken beforehand before his name could be incorporated.
So can the will be made electronically as claimed by some consultants? I think this question has been covered.
Yes.
Yeah. Now we have a
Yes.
question from Sanjeev Kumar Bazari. He has got 3 questions basically, 4 questions in fact. So I'm combining them all together. Probate is no longer necessary as the Repealing and Amendment Act 2025 has officially removed the mandatory requirement of obtaining probate in India. Registration of will is not necessary. Why then the Income Tax Department insists of registered will for registration of legal hire and raises objection when the will is not registered?
Now, this is very good point that he has made it out, because until 2025, probate was mandatory for the 3 cities of Bombay, then Chennai, and Kolkata. These were the 3 states where if you are having some movable, immobile property located in these particular 3 metropolitan cities in itself, then the probate was mandatory. There was no option for that in itself. But now, with effect from 2025, probate has not been made mandatory. It has been made optional now. In that case, it is always advisable to have a probate in order to avoid future disputes in itself. But once the family members are there who are agreeing for all the matters in itself, then the requirement of probate should not have been there. And that's what the government has rightly done. 121-year-old law has been modified, and accordingly now the probate provisions have been dispensed with. So that is the first issue that what you made it out. That is right, that probate is no more required. And whatever was being required, that was required only in these 3 cities. What was your second question, Deepika?
So he said that when the second question is, what if the witnesses predeceases the executor and the will is challenged in the court? Ye to ho gaya, sir. Will the distribution be made under succession laws simply because there are no witnesses available for explanation? I think this also has been
No, no,
covered.
no. No, when witnesses are not there, you have to read will as a whole in itself, because if the person's signature is being identified only because of the reason that witnesses are not there, witnesses are meant for only a particular situation, that the person who has made the will, that is the testator in itself, has executed that will. But since the legal document, this will is a legal document in the technical sense, only in absence of these witnesses, the will cannot be considered as invalid will in itself. Only thing is that the court will evaluate that what were the reasons as to why witnesses were not there, and it will be a matter of decision for the court to take. But in 90% cases, it will not be treated as invalid will. So
A
witnesses
person-
are mandatory, but that does not mean that ultimately they have to have a place. And if someone misses that particular witnesses category in itself, the will not become invalid.
So can I take up his third question now? It is, a person is Karta or member of his HUF. Can he make a will for his undivided share in the HUF? Will that be the individual property in the hands of the recipient or property of his HUF?
It's a good point again, because in Hindu undivided family, the shares are ultimately joint ownership is there. It's not co-ownership, it's a joint ownership. Every property belongs to everyone. That is what the meaning of the word joint property is all about. It is not co-ownership, it's joint ownership. So in that particular sense, just I can give one example. A cow is owned by two persons. It will be a joint ownership because everybody will be having every right so far as all the properties of the cow are being concerned. But in case of two cars, if one is owned by one and the other is owned by other, it will be co-owned in the technical sense because property is identifiable. When it is an impartable estate, then that cannot be divided. In that case, the ownership will be joint ownership. In other case, it will be a co-ownership basis in itself. In case of Hindu undivided family, unless there is a clear-cut partition in between the two persons or many persons of the co-partners in itself, and the share has been finally divided among the co-partners in itself, only that his share can be uh, willed it in itself. Other than that, the property cannot be kept unless it is partitioned, unless the share is identified. Share needs to be identified because in HUF, the entire property belongs to all persons. So as a result of which which property belongs to what or which person is not known. And that being the reason, the property cannot be willed out unless a separate segregation, his estate or his right has been identified, not only right, but the property also has been identified.
So, sir, in this case, it is like if the father owns is the Karta of the HUF and there are three sons. So one son claims that he has been given the share of the Karta, saying that this property belongs to you. So will that be possible in case
No,
of
no.
HUF?
No, once the property needs to be identified, that when there are one or two or three co-partners in itself, that is what I told you, that property's share is unidentified. Which part belongs to whom is not identified because east is belong to A, west is
He
belong to
wants
B.
to
If
transfer
that
the
is
entire
identified,
property, so that's not
so
possible.
entire property joint owner. So in
Yeah.
that case, you cannot say that property can be gifted or can be willed it out unless the property is partitioned and identified. Only that much portion of the property of HUF can be willed out by the concerned person. Not the karta can say that these are the aspects which are required because it's a survivorship. It's not the ultimate succession that matters. It is the survivorship that ultimately matters. And as a result of which, the more the number of members increase in the family, share reduces. The more the number of members decreases, the family share of the other parties increases. So that is the reason why the share is unidentified, and as a result of which, nothing can be done unless partitioned property is being there.
So there's a question: is it necessary to get the will registered if the original registered will is revoked by him, or the unregistered will shall become operative?
No, registered, unregistered wills, there are two different aspects. Once the will is registered, that is final. If the latter will is unregistered, because there is a specific law that once the earlier will is registered, and if you make any new will, the new will also has got to be registered. There is no option for that. So, as a result of which, earlier will, if it is unregistered and the latter will is registered, latter will prevail. But the earlier will is registered, but the latter will is unregistered, then registered will prevail. Unregistered will has no value.
Can separate wills be made for different properties, whether movable or immovable?
No, no, I'm not getting it. Please repeat again.
So, can separate wills made for different properties? If I have
Yes,
different
so
properties, can I make separate
no,
wills?
there is no need unless the property is huge. There is no need in that product because the mobile property can be handed over by delivery. Only the problem is there only in case of immobile property where problems are there. Now, in case of gold, cash, etc., these can be delivered at the time of death or even subsequent to death by mutual consent, and the property can be handed over. There is no problem about that. Only the problem comes up when the agriculture land, then the immobile property hands, then house properties, everything are there. Those create lot of problems. That is the reason why will is normally being required. But you need to specify even movable property as well, because I have given you one illustration that that lady died leaving behind a ornament necklace worth 18 lakhs of rupees, which ultimately lasted for 9 years debate in the court, and ultimately none of them could get it out, the necklace, ultimately 50% of the amount. That is what the result would be there. So that is the reason why we need to concentrate on these matters.
Abhirup Nandiji is asking that can you please discuss taxation on private trust through will?
Yes, why not? Why not? That is possible also, that who can be the trustee, or in default you can make it out certain matters, because ultimately these are the trustees who after your death normally take care of the private trust. So in that case, you can have n number of trustees, or you can have even default trustees also in there. But that ultimately creates problem. There is no need for, again, in that particular case, because the trustees ultimately will take care of the entire matter. And within, say, 30-40 years of time, the trust also vanishes, because normally there are clauses that after puberty, after majority, the property will become the owner of the property, will go to the beneficiary. So in that case, long-term requirement is not there in case of private trust, unless the beneficiaries are handicapped or mentally underdeveloped, non-developed. In those cases only. That is the reason why sometimes institutions are being appointed for such type of trust in itself, not the individuals.
Mr. Sanjay Garg is asking, can grandfather give his immovable property to his son and minor grandchildren? To his son and minor grandchildren.
Why not? The grandfather has every right to dispose of the property. But
Yeah.
if it is ancestral property, then there is a problem. If self-acquired property, there is no problem. He can give even without to son or grandson. He can even gift it to any charitable institution also. Unless it
Sandeep,
is an ancestral property, there are problems. Up to 4 generations you have to consider, and all those persons will get right in that particular property. The per capita distribution will be there, and the distribution on the basis of number of heads. All will get equal.
so the grandchildren will also be supposed to getting the share when the parents are alive in case of ancestral
Yeah,
property?
equal to that of, because the grandchildren have not done anything to get that property as like their father or grandfather. They are getting that particular property only because they are born in that family. So their contribution is zero. So father or grandfather has not done anything, but he got the property. Father has not done anything, but he got the property. Grandchildren are born and they have ultimately getting the property. So contribution of earning that property is nothing. So all will get according to number of heads per capita, and accordingly four are there. One, each one will get 1/4.
In case of divorce, like single parents, if the mother leaves the father and the custody goes with the mother, so in that case also he will have a chance to have a property right in the ancestral property?
Ancestral property, yes, there is no problem, because son is always a son. You cannot change the structure of the son in that particular case. So all legitimate sons are being covered from one marriage, from two marriage, or even from four marriage. So there is no problem about that. The legitimacy is never being challenged. If it is proved that he was the son, he is eligible from even ancestral property.
So alimony of the mother does not makes the property rights diminish in the property, right?
Yes.
Okay. So there is a question from Pramod Kumar Lodha, sir. Can a will have a clause that property should be transferred and shall not be sold during the lifetime of the transferee? Is it a valid will?
Yes, that can be possible. That is one of the ways by virtue of which the estate can be preserved, because it's a conditional uh, gifting of the property, build of the property. It's a desire of the person, as like the desire that he normally makes, that this particular property is given to you, provided you leave the habit of drinking a particular drink in itself. In that case, if it violates, then the question will come, the matter will go to the court. Nobody can get it executed. Only the beneficiaries who are under the will, they can only go to the courts and get the things done. But that can be one of the clauses in order to improve the health standard or the financial standard of the legatees are concerned.
Anish Shahji is asking a question. Can beneficiaries be executors?
Yes, beneficiary cannot be executor. They can be executor. There is no problem about that.
Because
Beneficiary
previously you
can
told that kids can be an executor as well, elder son or elder daughter.
witness cannot be
Like,
witness cannot be an executor in itself, but
yeah.
beneficiary can be. There is no problem about that.
Then we have a question. Separate will advised for properties as for ownership in case of sale of property. You cannot part with the entire will. Did you got the question,
No,
sir?
no, I'm not getting the question
Even
also.
I didn't get it. So let's keep it aside for a moment. He is requesting another session from you. Pramod Kumarji Rodha has requested, can we have a webinar by you on tax planning through trust?
Okay.
We'll take this up, Pramodji, for sure. Then Aditya Khade is asking, Karta of HUF dies without making a will, then who can become a new Karta? A wife or major son of deceased Karta? What is the procedure for appointing a new Karta?
No, previously, widow or wife was not being permitted to become karta in itself. Normally, in a Hindu undivided family, prominence is given to the male dominated community like male. And that is the reason why elder son normally would become. But since 2005 onwards, now there is no bar on the wife becoming the karta in the family in itself. Nobody does that in that particular case, but ultimately she can become, according to me, the karta of the family in
By
itself. There
default,
is
she
no
can
bar.
become?
Yeah, she can become.
Okay. Now we have Gopal Gurunandan Nayampalli. He's asking, will is prepared in favor of a 80-year-old person and that person died. What can that 80-year-old do considering his old age? I think the
Old age is
question is
not a,
asking that if somebody has passed on the will and that person has already expired, so where will all the assets go?
no, I'm not getting again. He was 80 years old, that I understood. He made a will, that also I understood. But what after that?
No, sir. The question, I think he has just wrote it in a separate manner. The question is basically, if I make a will in favor of an 80-year-old man, and before
80
that
years
will
old.
gets executed, that 80 years old person died. So in that case, what would be done?
No. In that particular case, the only option that is available to you is replace the name of the person. That's all.
So whatever the
Somebody,
higher of that 80-year-old is, it will go to them.
yeah, yeah.
So
Whatever.
that's all. And many people have said thank you for this lovely session to you. And a big round
Okay.
of applause for Dirip sir, because you've covered a very important topic. And some of the questions were added by me in between the session, like the one which I added for the Sun, because I recently read a newspaper cutting in which Karishma Kapoor is claiming a right on Sanjay Kapoor's property. So the new wife is denying that. So in that case, I was also curious that what should happen in that case. So I asked you the question in between. Thank you, sir.
Okay.
And it was a
I have
lovely
taken
session.
one. I have taken one question from the one of the attendees in itself, that we need to organize a small lecture on the tax planning through private and public
Yes,
trust.
sir.
That's what the will topic that ultimately has suggested all about. Other questions are similar, but since there were 380 slides and only 2 hours were available, normally this is a 6 hour session for me in
Sir,
itself.
it's a
Uh,
2 day session. We need 2 days
yeah,
from
yeah,
you,
yeah,
like 8 hour seminars every day. Then it will be covered. It's
yeah.
a very wide, extensive subject.
Yes, I had to move. I could not make it out even the small examples also, which could clarify the entire wording, because it's a law matter. No, we need to explain that in a common man's language, because it's not the topic that is well conversant with the all the chartered accountants or attendees in itself. So in that particular case, had that more time been there, then I would have been in a position to give more justice by way of giving some examples. So anyway, thank you, Deepika. You are
Sir, I will
the
request the management that we have a series of lectures from you on this particular topic. If we can design a course for you. So if we
yeah,
can
yeah,
design a course, we can just take up that course with you. So
yeah.
that would be a
Please suggest.
wonderful thing. So I
Yes,
would request
please
the
suggest.
management for this thing because even I love the session personally very much. And thank you so much for your time, sir.
Thank you.
Thank
Thank
you.
you. Thank you. Okay.
So we all can log out now because sir has given enough of time to us. Thank you everyone for being a part of this webinar. It was a wonderful journey. Thank you, sir. Looking
Thank you.
forward to having your course further.
Yeah. Thank you. Thank you.
Thank you so much, sir. It was a great session. Thank you, Deepika ma'am.
Thank you.
Thank you, Mayank.
Tech support, you can wind up now.